Should a single woman be denied the abortion rights that she is entitled to as a married woman? Supreme Court says no. Hello and welcome to India Today Digital. I'm Anjali Istwal and today we are going to decode law and women's right over their bodies. We will also tell you the highlights of the abortion law in India and the subsequent amendments to it. It all began with some comments made by the Delhi High Court in the case of 25-year-old single woman who was seeking permission to terminate her pregnancy after 20 weeks. The court told the petitioner, "Why are you killing the child? There are big queues for adoption. We are not forcing the petitioner to raise the child. We will ensure that the girl is kept somewhere safe and she can deliver and then go." The case was of a 25-year-old unmarried woman from Manipur residing in Delhi whose partner had, as she said, ditched her at the last moment and she did not wish to continue with her 23 weeks and 5 days old pregnancy in this present situation. But the Supreme Court holds a diametrically opposite opinion and the bench of Justices DY Chandrachud, Justice Surya Kant and Justice AS Bopanna said that petitioner should not be denied the benefit merely on the ground that she is an unmarried woman. The bench directed the AIIMS director to set up a medical board of 2 doctors to examine the woman and determine whether the pregnancy, if terminated, could risk the life of the woman or not. Let's try and understand why the relationship status of the woman denied her the right to abortion. The woman challenged Rule 3B of the Medical Termination of Pregnancy Rules 2003, as per which only some categories of women are allowed to seek termination of a pregnancy between 20 to 24 weeks. The list does not include unmarried women in consensual relationships. The lawyer representing the young woman claimed that she is not physically, mentally and financially prepared to raise this child, being a single unmarried parent. Giving birth to the child out of wedlock would cause her immense mental agony and physical hardships and pain. It will be a social stigma for her and the child also will be an illegitimate child. While hearing her petition, the division bench of Chief Justice Satish Chandra Sharma and Justice Subramaniam Prasad even asked the senior counsel Kapil Sibal for his opinion as he was present in the court. Mr. Sibal called the decision tough but said that the child shouldn't be aborted at this stage as per his personal opinion. Chief Justice Sharma then said, "I am suggesting a way out. We will ensure that she is kept somewhere in a safe hospital and she can deliver and then go. There is a big queue for adoption." The court also clearly emphasized that it was not forcing the woman to raise the child and would ensure that she was sent to a good hospital and that everything will be looked after by the Government of India or Government of Delhi or some good hospital. The Chief Justice even said, if the government does not pay, we are there to pay. While the court asked the lawyer of the young woman to go and consult the woman, by the afternoon the court was told that the woman did not want to continue the pregnancy. Her counsel argued that the MTP Act is progressive in nature, but the rules framed under it exclude unmarried women. He said that if there is a widow or divorcee, then there is no need for permission. The law allows up to 24 weeks. The problem is that she is unmarried and she is excluded from this. The MTP Act was amended in 2021, after which the permission for abortion up to 24 weeks was granted, but in some categories, and these categories don't include single unmarried women in consensual relationships. Now let's do a deep dive into the abortion laws in India. The first ever law for it was framed in 1971 and was thus called the Medical Termination of Pregnancy Act or MPT Act 1971. And after 40 long years, it was amended in 2021. The amended act said that the limit for termination of pregnancy that was set at 20 weeks was relaxed in special cases that included pregnancies resulting from rape, pregnancy born by a minor, or a woman whose marital status has changed. That would include divorced or widowed women. The act allows abortion after 24 weeks only in cases where a medical board diagnoses substantial fetal abnormalities. This implies that for a case requiring abortion due to rape that exceeds 24 weeks, then the only recourse for them remains through a writ petition. Recently, the Delhi High Court has allowed a minor rape survivor to undergo medical termination of pregnancy after 26 weeks, saying her misery and suffering would stand compounded if she was forced to bear the mantle of motherhood at such a tender age. Although the law provides sufficient protection, and as Supreme Court has exhibited, courts are there to help interpret the law in a more inclusive manner. But still, there are many women who are opting for unsafe methods of termination of pregnancy. Sometimes it's lack of proper knowledge about your rights, and sometimes it could be the age-old shame instilled in women by society. Moral policing of a woman's every decision extends to the right over their bodies also. But this can lead to the horrible finality of a death of a pregnant woman. Data by Health and Family Welfare Ministry states many women die every day due to unsafe abortions. We hope this will change as the women of our country become empowered and health and education indicators for women improve in the future. Please do comment and tell us what you think about the abortion law and the rights of women by commenting on the video. Also, do subscribe to India Today YouTube channel to get your daily dose of news and information. Namaskar.